Welcome to What's Trending. The Caribbean Court of Justice ruled that the no confidence motion against the Guyana government, which was tabled by the opposition, was properly passed. You knew this, I knew this, and the government knew this. Before we get into today's show, if you are new here, please press that red and white subscribe button and turn on post notifications if you want updates when we upload new videos. So, David Granger accepted the guidance of his advisors to stall elections via a lengthy litigation process, but they have finally reached the end of that road. Oh wait, they haven't, because they are still touting house-to-house registration, which will further delay elections that was supposed to be held since before March 22nd. I have never had any real problems with President Granger, but after seeing how he frustrated this process, I cannot trust him anymore. It's not just about his refusal to carry Skunt after the no-confidence vote, but his extensive use of jiggery-poogery tactics to do so. He installed a partisan chairman in the Elections Commission and used that chairman to delay elections. I have a question for you viewers who have been following this whole thing. If we sit Mr. Patterson down and hook him up to a lie detector, when the question, were you instructed by the president to delay elections, is asked, if he says no, do you think that lie detector machine will blow up? Be honest. Let me hear your thoughts in the comments. Anyways, the Caribbean Court of Justice ruled that Granger's unilateral appointment of the GCOM chairman was flawed and unconstitutional. They also ruled that the no-confidence motion against the government was properly passed. So what now? Neil Marks from the newsroom will explain.
The big question is what happens next, and as has been the case since the no-confidence motion, no one knows at this point. The uncertainty continues. The president of the court, Justice Adrian Saunders, urged the parties to engage with each other and come up with a consensus. This will no doubt prevent the court from having to force an order on the government. On Tuesday morning, the court ruled that the December 21st no-confidence motion was properly passed in the National Assembly. 33 votes in the 65-seat House, the court ruled, was the majority, and not 34. Justice Saunders summed up the judgment.
The relevant act in these circumstances was the National Assembly Validity of Elections Act, which required that a petition alleging that Mr. Prasad was disqualified from running for office be presented within 28 days after the results of the 2015 elections, out of which the matter arose, was published in the Gazette. The court emphasized that it had long been recognized that this election petition procedure was intended to be an exclusive one. The court held, by a majority, that the court had no jurisdiction to consider the question of the validity of a member's election to the Assembly by any other means. The majority emphasized that the court had no inherent jurisdiction to exercise in order to address the issue of disqualification of a member. The 28-day period having expired, the court therefore lacked jurisdiction to assess whether Mr. Prasad was disqualified at the time of his election. The court also held that there was no need to consider whether Mr. Prasad's seat ought to be declared vacant in accordance with Article 156(1)(d) of the Constitution, because Article 156(1)(d) applied to supervening events that caused a person to become disqualified while he or she was a member of the Assembly, and Mr. Prasad's disqualification clearly arose before he became a member. And 2. Mr. Prasad had already been recalled and removed from the National Assembly on the 3rd of January 2019, the very day before these proceedings were initiated in the High Court. Having concluded that the court lacked jurisdiction to impeach Mr. Prasad's election, the court found that there was no real need to ascertain whether Article 165(2) preserved the validity of Mr. Prasad's vote on the motion. However, even if the court had jurisdiction to declare Mr. Prasad's election to the Assembly to be void from the outset, the court agreed with the courts below that Article 165(2) would have preserved the validity of his vote. Finally, the court rejected the submission that Mr. Prasad was absolutely required to vote against the motion of no confidence along with other members of the government list unless the party's whip granted permission for a so-called conscience vote. The court found that nothing in Article 156(3) or anywhere else in the Constitution prohibited Mr. Prasad from voting against the government on any particular measure. Such a vote may well cause the representative of his list to remove him from the Assembly. but his vote would still be valid. Having regard to all the findings above, the court held that the National Assembly properly passed a motion of no confidence in the government on the 21st December 2019, and that the provisions of Article 106, 6 and 7 were accordingly triggered.
The CCJ ruled that with the passage of the motion, Article 106, 6 and 7 were triggered. The Constitution clearly states that with the passage of a no-confidence motion, elections must be called in 3 months unless the deadline is extended by the Parliament. That did not happen. Elections now has to be called. President David Granger announced today that he will call those elections, but not immediately. He's sticking to the late November date given by the Guyana Elections Commission.
It is now clear that the Guyanese people need certainty about the future and a way forward. I want to outline a clear path. It is essential that we hold fair, free and credible elections. We cannot proceed on the current list of voters. It is outdated and corrupted. It may hold as many as 200,000 incorrect entries. What is more, those who have reached the age of 18 years since the last election are not in it. The Constitution entitles all citizens over the age of 18 the right to vote. It is a democratic imperative that house-to-house registration be completed swiftly so we can have an election at the earliest opportunity. The chairman of the Guyana Elections Commission, Justice Patterson, has previously informed me that the Commission will be ready to hold elections in November 2019. This will be after the completion of house-to-house registration. I now await a recommendation for a specific date from GCOM, and I will then issue a proclamation.
On Tuesday afternoon, the opposition leader Barra Jagio reacted furiously. As far as he is concerned, the government has been illegal since March 21st, and during this time, legislation governing the spending of oil resources was passed, while the government also passed supplementary budget estimates in the billions and also awarded billions in contracts. And so he was alarmed that even with the CCJ ruling, the president is insisting on the late November timeline, saying house-to-house registration must be held first.
I'm not going to say anything anymore. I've not amended my opinion of the president. I've not changed it. I just believe that in spite of all people say, that he knows what's going on. He can't be oblivious to the daily corruption, the wanton theft of state resources. And he presents himself as aloof from all of this. And he cannot be oblivious to the implications of the ruling. Cannot be oblivious to what Articles 106.6 and 106.7 of our Constitution say. Cannot be oblivious to all of these things, yet he insists on this. He didn't insist, this list expired in April 30th. He didn't insist that we do this before the local government elections. He didn't insist. This guy is hanging on. He sees the writing on the wall. He's hanging on for his few last days as president, hoping that somehow, through this wanton theft and use of state resources for campaigning, they can change their electoral fortune. And that's what he's doing. This is another Granger dissing the Constitution like he did with the appointment of the chairman of GCOM. This is Granger saying, ignore the Constitution. What I say matters. I'm going to tell you what you need to do. You have to go and do the house-to-house, and then I'll hold elections. He has no such powers in our Constitution. But this is another issue of Granger acting above the Constitution that he just got struck down by the CCJ for. You saw what the CCJ is saying. You're living basically on borrowed time. These people have squatted on government illegally for a long while. They've been squatting in government. They go run after the squatters and try to throw them off the streets. And when I said chase them out, they wanted to lock me up. But they've been squatting in government. And today has confirmed that there are a bunch of squatters, corrupt squatters.
Mr. Anil Mandlal, attorney for the opposition leader, had also spoken on the issue just after the ruling.
I want to say that the people of Guyana and democracy have triumphed, and the Constitution has triumphed today. As I said from the beginning, this case should never have been filed. It was a waste of resources, a waste of time. Fortunately, we have come to the end. And fortunately, the court, in its wisdom, has seen it fit to fix a date and time for us to at least try and come back and work out some kind of arrangements in terms of the consequential orders. I think the court has made a clear hint of where it is going in the absence of an agreement in that respect, because the court said that the Constitution itself has set out certain guidelines, and the president of the court, in his summary just now, indicated that that is more expressly and elaborately stated in the judgment. What the court is really hinting at there is that in the absence of an agreement, the court will have to take the initiative, and the court doesn't really want to do that, to make coercive orders for early elections. So this shenaniganism that's taking place at GCOM with house verification will have to be stopped, and the Constitution will have to be given effect to, which is early elections.
Would you think a new chairman at this point in time would be the right thing?
Well, that is one. Well, the chairman's appointment has already been declared to be unlawful. So that is a given. That's where we have to start from. Whether it's a right thing or a wrong thing, we can't question that. An unlawful act cannot be countenanced. So the chairman will have to go. And that is why the judge, at the end of his ruling in that matter, specifically said that he must be addressed, or the court must be addressed on consequential orders. Meaning that I believe the court recognizes strategies of dilation and delay which have preoccupied this process, and the court is indicating that it may be influenced to order time frames within which a next chairman is to be appointed.
Now, apart from the ruling that the no confidence motion was properly passed, the court also ruled that President David Granger was in breach of the Constitution when he unilaterally appointed Justice James Patterson on October 19, 2017. The President used the proviso of Article 161(2) of the Constitution to appoint Patterson, saying that he was forced to because three lists submitted by the opposition leader were not acceptable to him. Member of Parliament Zulfikar Mustafa complained that the process engaged by the President was flawed and invited the court to quash the appointment and choose one of the 18 persons nominated by the opposition leader, Bara Jagdeo. The court had this to say.
It was not clear what process should be followed to accommodate the spirit of consensus that must prevail between the President and the Leader of the Opposition. The court decided that the most sensible approach to operationalizing the article was for the Leader of the Opposition and the President to communicate with each other in good faith, and perhaps even meet to discuss eligible candidates for the position of chairman before a list is formally submitted. The aim of these discussions should be to agree the names of 6 persons who fit the stated eligibility requirements and who are not unacceptable to the President. In this regard, the court noted that the Constitution anticipates that the Leader of the Opposition and the President will conduct themselves in a reasonable and responsible manner, eschew partisanship, and seek the best interests of the Republic and the Guyanese people. The court was also of the view that the employment of the double negative, not unacceptable, signals that an onus is placed on the President not to find a nominee unacceptable merely because the nominee is not a choice the President would have himself made. By a majority, the court found that the President should only find a nominee unacceptable for some good reason on objective grounds. If a President were permitted, capriciously or whimsically, without proffering a good reason, to reject eligible nominees, this would frustrate the proper working of the Constitution. It would defeat the intention behind the amendment to Article 161(2), and it would pave the way for unilateral presidential appointment. The court found that once the President and the Leader of the Opposition have hammered out a list of names not unacceptable to the President, the list, comprising those 6 persons, must then formally be submitted to the President by the Leader of the Opposition, and the President must then select a chairman from among those names. In the Court's view, such an approach gives the President a role in the identification of the 6 names, but obviates the possibility that after the formal presentation of the list, the President could suggest that one or more of the names, or indeed the entire list, is unacceptable. In those circumstances, a unilateral appointment by the President, in keeping with the proviso to Article 161(2), can hardly be an option if the Leader of the Opposition demonstrates a willingness to engage in good faith the process outlined above. The Court reviewed what transpired between 22nd November 2016 and 19th November 2017, and the Court determined that the President was not entitled to lay down, as a precondition to considering a nominee, eligibility requirements that were additional to or at variance with those prescribed by the Constitution. The Court emphasized, however, that nothing in its judgment was intended in the slightest degree to cast aspersions on Justice Patterson's competence and suitability for the position of Chairman of GCOM. Nor was there any suggestion that His Excellency acted otherwise than in good faith. Accordingly, however, in view of the unfortunate process that was followed, in view of the imposition on the Leader of the Opposition of criteria that were not sanctioned by the Constitution, and in view of the absence of cogent reasons for deeming unacceptable the candidates and lists provided, the Court concluded that the process that was followed in the appointment of Justice Patterson was flawed and in breach of Article 161(2).
It remains now to be seen what orders the Court will make. The big questions are, will there be a consensus on what happens next? Will the parties agree on a date, or will the Court have to force an order? Regardless of which date is set, what happens to the Chairman of GCOM? Will he be replaced before the elections are held?
Hey, newsroom stinks of PPP. I hope this gives you some insight of what the current situation is. Of course, I will stay on top of this story and make sure I bring you the latest. Don't forget to subscribe. My name is Mudwata. Boom out!
Hold up.